This is the final part of the interview that I did with Jose Silva Jr., an attorney in Vineland, New Jersey, and this section is all about advanced medical directives. So we'll start with the first question. Jose, what is a healthcare directive?
A healthcare directive has two components. The first component is the instruction part, where you are authorizing certain types of treatment from your medical provider. And it's pretty specific. And I will ask my clients, if you are, for example, in a medical condition where you have days to live and your doctor says there's this experimental medicine, do you want the doctor to start injecting you with this medicine? Or if you have only 2 to 3 days to live, do you want to be pain free? Most of them will tell me, I do not want anything that will try to prolong my life, because I want to be pain free and I want to die with dignity. And that's really what it comes down to. What are your preferences at your last days of your life? Do you want to be poked and prodded, or do you want to live comfortably, pain free? And that's what the instruction sheet will go through. Do you want your organs to be donated? If you're pregnant, do you want certain things to happen? That's the instruction sheet. The healthcare directive itself, you are really appointing what I call an advocate. We call it an attorney in fact, but the advocate would be the person. And I ask the client, when it's your time for your plug to be pulled, who do you want to make that decision? And they will say, well, I can have my husband or my son, or I have a daughter. She's hardcore. She will not let her emotions get to her. And that's really what the healthcare directive says. You appoint the attorney in fact to not only get medical information about you, but also to make those decisions. And once I have a healthcare directive signed, I have the client, I instruct them, you should give a copy of your healthcare directive. Some people call it a living will, but I direct them to give a copy to their minister and their healthcare provider, so that the healthcare provider knows exactly what they want done. And usually the healthcare provider should ask questions from them. Well, what do you want me to do in this type of situation? Who do you want me to call? They should have that in their files in case the attorney in fact or the advocate is not available, that the physician knows what they want. The reason why I also instruct them to give a copy to their minister, their rabbi, their priest, is that they would know the intentions of what they want done at the last stages of their life. So if the healthcare advocate is not available, they can't be located, and you have usually alternate number two, and alternate number three. If they are not available, you want someone who knows what your intentions are. An example, let's assume the person is a Jehovah's Witness, but they have no documentation. Usually the Jehovah's Witnesses will carry in their wallets a small portion of their living will regarding the transmission of blood. They don't want any transfusion of blood. That's specific. But let's assume something happens and not in their wallet, but their minister knows that there's a healthcare directive, or their healthcare provider knows it. They at least know that they don't want any blood transfused. No transfusion at all. Let's assume it's someone from a different type of religion, or someone who does not want any type of medicine to prolong their life. The healthcare advocate would know that. In addition, when I do a healthcare directive and the instruction, I usually do it the same way I would do a will or a power of attorney. I have witnesses to show that the person signed it of free will, that they did it voluntarily. Nobody forced them. Nobody put a gun to their head to get them to sign this healthcare directive or to appoint that individual as healthcare directives. The healthcare directive is a little bit more simpler as opposed to a power of attorney, because to me it's pretty straightforward as the type of things you want and don't want done. It could be that you're in a coma and the doctor doesn't say you're going to die, but it might be that, for example, that you are brain dead and you appoint someone to pull that plug. Everyone's familiar with the term pull the plug. That's the person who's going to make the decision. Am I going to let my grandma, am I going to pull the plug on grandma? And everyone is fighting with you. No, don't do it. But you're the only one with that key. You're the only one with that authority to tell the physician, I need you to do this, because if she's brain dead, that means she's already dead. Different from someone who's in a coma. There's a case that occurred some years ago, and I forget the name of the case, where the woman was in a coma for like 15 or 20 years. And the husband was fighting with the in-laws about who was going to have the authority to pull the plug. And it went, I believe it went up to the Supreme Court of the United States. That's why it's important to have this type of document so that there are no, you're trying to avoid the litigation going to court, because you could be, by going to litigation, prolonging that person's pain and anguish. And if they've already provided in written form voluntarily, who's going to be the healthcare advocate? Who is the individual that they say, this is my attorney, in fact, that I'm assigning with authority to do certain functions? And you have witnesses to that effect. I don't believe that a court would prolong that type of litigation. It could, but it's less likely to occur.
So if someone's appointed as the attorney, in fact, you need to know that they're very unwavering. And if you yourself are appointed attorney, in fact, you need to know that you can handle it.
Right. You want to appoint someone as the attorney, in fact, who will carry out your intentions.
And who should have a healthcare directive?
Everyone. Everyone over the age of 18 who's an adult. With children, it's different because they can't enter into a contractual obligation when they are under the age of 18. Once they are 18, they can enter into contractual obligations. But everyone should have a healthcare directive instructing the healthcare provider and their attorney, in fact, what they want performed in the event certain conditions occur.
And what happens if somebody doesn't have a medical directive?
What happens then? You open up the door to infighting between the family. And I have not seen this happen in a hospital setting, but I have heard that siblings begin to enter into heated disputes in a hospital setting or outside the hospital, potentially coming to blows or hiring attorneys because one sibling does not want their parent to die, and the other sibling says, the time has come. Mom has died, or grandmom has died, or our aunt is brain dead. We need to pull the plug. And now there's litigation. Now each of them are paying attorneys and going to court. And there's all this acrimony in a family setting. Instead of allowing mom or grandmom to die peaceably, she potentially is experiencing all of this acrimony and all this fighting.
Okay, and what about like smaller decisions then? Who would make the decisions, say, to have a blood transfusion or take certain types of medication if someone's incapacitated and they don't have the healthcare directive?
Again, that would be if there's fighting, the potential outcome is that, and I've seen this happen where the hospital does not have a clear indication because of fighting. The hospital then, they hire their attorney who then asks the court to make a decision. And it could be in the form of a guardianship. Court, we are now confronted with this situation. We don't want to be liable. Someone has to make this decision. And then they put it on the court.
Now, what should somebody know before they meet with their attorney to establish their healthcare directive?
They want to know what events, what they want performed on them in the event they are not able to communicate that to the healthcare provider. Do they want to go through the experimental medicine, through x-rays, or do they want to die comfortably? Do they want to donate their organs? And it's up to them. Another thing that's been happening, and now it's new in New Jersey, for example, assisted suicide is not permitted. There's now a bill in New Jersey that potentially could pass where you could have what's called a mercy killing, where the doctor could inject you with X number of medicines to help you die more peacefully. I don't know to what extent it'll happen. There are not many states in the United States that allow this type of mercy or the mercy suicide, but it's something that is now coming to New Jersey and it's in the legislature. So the person should know, I'm going to meet with my attorney. I need to know what I want done to me specifically in the event I cannot make a decision, I'm incoherent. And you could be incoherent for a temporary period. For example, you could have been in a car accident and you lose total consciousness or you forget who you are. So those are the type of situations that you want to protect yourself with.
All right. Thank you for all that information, Jose. This has been a great interview on medical directives. The content provided herein in writing, audio, or by video is for informational and educational purposes. The content is not intended as legal advice to the individuals reading, listening, and/or viewing any of the content herein. Each case is different, and as such, by accepting to view, listen, and/or view the content, no attorney-client relationship has been established between Jose Silva Jr. and his law office of Jose Silva Jr. Attorney at Law LLC. Furthermore, the information here is a marketing tool and advertisement by Jose Silva Jr. Attorney at Law LLC and its employees, agents, and representatives. Should you have any questions regarding the content herein and wish a consultation with Jose Silva Jr. Attorney at Law LLC, you must set an appointment for a consultation and pay the required consult fee. At that time, further and perhaps more specific information may be provided as it pertains specifically to individual cases. Neither Royal Alliance Associates Inc. nor its registered representatives or employees provide tax or legal advice.
Securities and insurance services offered through Royal Alliance Associates Inc., member FINRA SIPC. Insurance services may also be offered through Harbour Master Diversified Financial Services Inc. Advisory services offered through Investment Advisors Asset Management LLC, a registered investment advisor. Royal Alliance Associates Inc. is not affiliated with either entity.